Right, good morning everybody. Good morning to anyone who's watching this live. First of all, I think, I know it's getting towards the end of January, but I'd like to wish everybody a happy new year, first of all. And we'll move on to agenda item number 1, please, which is apologies.
Good morning, Chairman. We've received apologies from Councillor Abrahams.
Thank you. And item number 2, please, which is declaration of interest in accordance with Standing Order 16.2. Has anyone got any interests they want to declare? No, none from me. And we'll move on to item number 3, which is the minutes of the meeting, which seems a long time ago, on the 10th of December 2021. Is everyone happy with the minutes? Moved and agreed. Thank you. And we'll move on to item number 4, which is Wildlife and Countryside Act 1981, and it's an application for the addition of a public bridleway from byway number 3 north of Stable Farm to Trent Walk, Ingestry. And I presume this is you, Hannah.
Yes, thank you, Chair. Okay, so as already stated, this is an application for the addition of a public bridleway from byway number 3 north of Stable Farm to Trent Walk in the Parish of Industry. The route is marked C to D at Appendix B. So the application was submitted by Mr. Martin Ray. In support of the application, Mr. Ray submitted a quarter session order dated 1801 and estate maps of industry. You may recall that these documents were also submitted in relation to the reports heard at December's panel. So you may recall that the 1801 quarter session order sets out a diversion and also stops up a length of bridleway in front of Industry Hall, and it turned the bridleway onto a new line. So the order refers to a length of 739 yards of old bridleway that was stopped up, and the bridleway was to be diverted onto a new line, which took the bridleway from the end of Dog Kennel Gate in a northwesterly direction, and is the route subject to this application. The route then looped round from the end of Trent Walk to terminate on the A518. So this section of route was discussed at December's panel. Back to this route, the order shows that the Earl of Talbot consented to the diversion of the bridleway and that the bridleway use would be for the public. So the road on the order map runs from Industry in a northwesterly direction. It then turns to northeastwardly to join Trent Walk. And again, this is the part of the route subject to this report. The authenticity of the 1801 order has been confirmed by Dr. Fawkes, who is a historical researcher and consultant archivist. So when considering the old bridleway, it is apparent that it ran in front of the hall from Tixall Park Gate to Dog Kennel Gate, and then towards Trent Walk, which can be seen on the plan at Appendix C. So the new bridleway, whilst the order mentions it from commencing from the end of Trent Walk, it also forms part of the old way not stopped up, so that is the part from Dog Kennel Gate to Trent Walk. And again, this is the route marked C to D on the map at Appendix B. So it would appear that the Earl of Talbot allowed the route from Dog Kennel Gate to Trent Walk as part of the diversion, and that people use the route as part of the bridleway network surrounding Industry Park. There's no conclusive evidence been put forward or from the order itself that the route subject to this report had any rights extinguished over it. So there does appear to be an intention that this part of the route would be used by the public as a bridle way, connecting with the diverted bridle way to Hopton and that connected to Trent Walk. So whilst it has been difficult to ascertain the exact line for the alleged route, the evidence is settled on the line marked on the appendix, on the map at Appendix B and marked C to D. So the alleged route does now pass at an angle through properties that have been built in recent years. Due to the age of the historical documentation and the development of new housing in the area of the alleged route, as stated, it has been slightly difficult to ascertain the exact line the alleged route would have taken at the time of the 1801 order. However, overlaying the order map onto a modern ordnance survey map has assisted in providing an accurate summation of where the route lay. In the case of Roxina, it was determined that it was not lawful for a council to reject a recommendation for adding a route to the definitive map and statement because there was insufficient evidence in relation to the alignment of the new rights of way on the map, particularly where it was impossible to discern from available evidence with sufficient precision where the route would run on the ground. It was specifically stated in that case that the obligation on the surveying authority is to make a judgment on the basis of the best evidence it has. So in this case, this has been done based on the quarter session order and the order map being overlaid onto the definitive map, which you can see attached at Appendix E. Following circulation of the report, the applicant did provide 2 further documents to support the alignment of the route, and copies of those are attached at Appendix I. So when taking everything into consideration, the bridle way in its entirety would therefore be from the direction of industry through Dog Kennel Gate to Trent Walk. No orders or other documentation have been discovered to suggest that the bridle way from Dog Kennel Gate to Trent Walk has ever been the subject of an order extinguishing any public rights. In the absence of this contrary evidence, the evidence is strong that the alleged route remains a public bridle way from Dog Kennel Gate to Hopton Heath. Following circulation of the report, a number of objections have been received from a number of different landowners and also from industry with Hixson Parish Council. So industry with Hixson Parish Council, along with a number of landowners, as detailed in the report, have responded stating that the alleged route had been extinguished. So it can be confirmed that in approximately 2010, an attempt was made to try and resolve concerns about the alleged route by potentially having the route diverted. That would have required all landowners affected by the alleged route to have agreed to the diversion. Also, in order for the diversion to take place, the original route would need to first be legally extinguished. And in order for that extinguishment to take place, it would have required all landowners to accept the existence of the route. Unfortunately, an agreement could not be reached by all the landowners affected by the proposal to the extinguishment and diversion of the route, and therefore it didn't take effect. So we can confirm that the route subject to this report has never been legally extinguished, and therefore it continues through the Section 53 process, and hence why it's here today at panel to determine whether the route exists or not. Other concerns that have been raised by landowners include concerns about damage to properties and wildlife in the area, and also the potential negative impact on animals grazing on land affected by the proposed bridle way. So whilst it's not our intention to belittle any concerns raised, issues relating to safety, suitability, privacy or maintenance cannot be taken into consideration. Only material relating to the physical existence or status of a way can be taken into consideration under the law as it currently stands. Some evidence has also been put forward showing that post-1803, the Earl of Talbot developed his land in the area where the alleged route runs, and therefore may have built over the alleged route due to the construction of Home Farm that was established in approximately 1820. So it may be that the Earl of Talbot did develop his land post the 1801 order. However, even if a route falls into disuse or is developed over, this does not automatically mean that the route or any public right-of-way ceases to exist. It can only cease to exist if the route has legally been extinguished or if it physically ceases to exist. So, for example, a cliff path that gets eroded into the sea. There's no specific evidence been put forward that the route subject to this report has ever been legally extinguished, so therefore the maxim is, once a highway, always a highway. So in the absence of the 1801 order or another legal order extinguishing any rights over the alleged route, it must be taken that the route still legally exists, even if it has since been developed over. Some issues have also been raised regarding the authenticity of the 1801 order, and some views have been put forward that the order may have been amended or doctored. As already stated, the order has been verified by Dr. Fawkes, and without any specific evidence showing that the order is invalid, we have no reason to believe that the order does not have legal effect. One landowner has also provided a Yates map dated 1789 of the industry estate. They allege this shows the position of Tixall Park and Dog Kennel Gate in a different position to the 1801 order. However, on review of both documents, they do appear to show the points in approximately the same location. The Yates map does actually show the physical existence of the route subject to this report, although this type of map in itself generally doesn't provide any evidence as to the status of any public rights over an alleged route. Further maps of the industry estate have been provided which post-1813 do not show a route along the line of the alleged route. There does appear to be, however, another route shown from the bottom of Trent Walk, which leads in a more straighter westerly direction and runs towards the back of Industry Hall. This is possibly due to land having been developed along the line of the original route. Therefore, there is some evidence that the route subject to this application has fallen into disuse, as it has no longer been felt necessary to include on later maps. However, as already stated, this on its own does not prove that the alleged route has legally been extinguished, as there's been no legal order provided showing this. So in relation to this application, there are two tests that must be satisfied before a modification order can be made. So the first test is to show that the public right-of-way exists on the balance of probabilities. So therefore that it is more likely than not that the public right-of-way exists. The second test is whether it can be shown that the public right-of-way is reasonably alleged to subsist. So it is officer's opinion that the route subject to this report was never legally extinguished as part of the diversion of the 1801 order, and there was no evidence to show that this route has had any public rights extinguished over it. Therefore, it is officer's opinion that the alleged route on the balance of probabilities does subsist as a public bridle way. Thank you. I'm happy to take any questions.
Thank you, Hannah, for a comprehensive report. Obviously, we had several items on the previous meeting on this, so we're all well versed in this. Have members got any observations, questions?
It's more just observations, really, from what's been said. I mean, as we all know from our training, that once a route is there, it can never be extinguished. And as Hannah's brought up, there was dispute between the various landowners whether it should be extinguished or not, and for that reason it was never extinguished. So, like, go back to the 1801 order, it's a court order, which can then only be overtaken by another court, and there's no evidence to say that's happened, so we can't go along with that. It shows that the highway bridleway was in existence. So really on the balance of probabilities, I'll put forward that we accept the officer's recommendation.
Have we a seconder?
I'm happy to second the officer's recommendation.
Thank you, David. We've got a proposer, a seconder. All those in favour of going with the officer's recommendation to permit. Okay, so that this footpath will now be put onto the definitive map. Thank you, Hannah. And we'll move on at that point to item number 5, please. Again, Wildlife and Countryside Act 1981, and this is the application for the addition of an alleged public bridleway from Trent Walk Bridge to the public road at the southeast corner of Home Farm. This is you again, Hannah.
Yes, thank you, Chair.
Thank you.
So yeah, as stated, this application is for the addition of a public bridleway from Trent Walk Bridge to the public road at the southeast corner of Home Farm in the Parish of Industry. So this report is based on applications submitted by Mr Martin Ray and also an application submitted by a Mr Martin Bridal on behalf of the Cyclist Touring Club. So the report is based on historical evidence, in particular, again, the 1801 quarter session order as already discussed, but it's also based on user evidence from members of the public. So in terms of the user evidence, in order for the application to be successful, it will have to be shown that the public have used the alleged route as of right and without interruption for a period of at least 20 years prior to the status of the route being brought into question, or that it can be inferred by the landowner's conduct that they have actually dedicated the route as a public right-of-way, and this right-of-way has been accepted by the public. In this case, there doesn't appear to have been a specific challenge to use of the route, and therefore the date of an application for a modification order under Section 53 can be used as the date at which the public's use was brought into question. So the application was made in 1999, therefore the requisite 20-year period is from 1979 to 1999. So of the 23 user evidence forms submitted, 8 users have over 20 years usage, which covers the relevant 20-year period between 1979 and 1999. 2 users, when their evidence is combined, also make another 20-year period. The remaining users have all used the alleged route for varying periods of time, but which is less than 20 years. Only 1 user has claimed to have been turned back by a landowner when attempting to use the route, and this was recorded in 1999. Despite the application being for the addition of a bridleway, only 2 of the users claim to have used the route on horseback. 12 of the users claim to have used the route by bicycle, 15 on foot, and 4 using a motorised vehicle. The evidence of frequency of use does vary, with 2 users using the route monthly, 1 user being daily, and 4 users being yearly. As already discussed, the quarter session order sets out a diversion which stopped up a length of bridleway in front of Industry Hall and turned the bridleway onto a new line with the consent of the Earl of Talbot. In a deposition that accompanies the order, it describes the original bridleway running from a place called Trent Walk, which is described as being located at the end of the bridge over the River Trent. On the order plan, Trent Walk is shown written above the line of the route running towards the River Trent. The Earl declares that he will maintain the new bridleway and that the bridge erected over the River Trent will be a public bridle bridge that will also be maintained by the Earl. So just to clarify, the evidence of use is for the whole of the alleged route, that is from Trent Walk and Home Farm Court. From the evidence, it does not appear that any of the users have used force when using the route, and they are not drawn from a particular section of society. There is nothing in the legislation or in the case law that sets out a minimum level of user that is required to support a claim that a route exists. The case law does, however, suggest that the use should be sufficient to bring home to a reasonable landowner that the public are using a way as a highway and therefore they're using it as of right. The frequency of use in this case could be said to be slightly sporadic. If a presumption of dedication can be shown, then the burden then lies with the owner to demonstrate that there is no intention to dedicate. This is often done by erecting notices or putting in place obstructions to use of the route. A number of users have referred to gates along the route, with three users stating that there is a gate at Trent Lodge and one user stating that there is a bridal gate at Trent Lodge. So although reference has been made to gates along the route, there was nothing in the evidence, though, to suggest that the presence of any gates along the alleged route did prevent use of the route. The evidence also needs to be considered under common law. So only 8 users have provided evidence of 20 years uninterrupted use. However, when the application is considered under the common law, which does not require specifically 20 years uninterrupted use, 23 people have provided evidence of use. Also, only 2 users have claimed to have used the route on horseback, so this evidence of use does not wholly support the status of the route being claimed for, in that there is little evidence that the route is being used specifically by horse riders. The majority of users indicate that the route is predominantly being used by walkers and cyclists. The fact that the evidence shows that the route is being used by walkers, horse riders and cyclists does lend some weight to the contention that the route has bridle rights over it, as it is still being used in a manner which is consistent with use of a bridle way. So going back to the quarter session order, this does deal specifically with Trent Walk. So as already stated, it deals with the stopping up and diverting of a section of bridle way. So Trent Walk itself is not part of the stopping up or diversion of the bridle way. However, the order does provide strong evidence that Trent Walk was part of a bridle way network within the area, and the order refers to a public bridle bridge along Trent Walk. It is also clear from the order that the diverted bridle way will connect with Trent Walk as a connecting public bridle way, supporting the route status being a public bridle way. Following circulation of the report, a number of objections were received from a number of different landowners regarding the proposed route. A number of landowners have stated that members of the public have been seen using the route and have been challenged when using it, being advised that the route is private and they should not be using it. So this is contrary to the user evidence provided. One landowner has stated that there have been businesses, friends and associates of landowners using the route, which may at times have meant that members of the public have gone unnoticed by landowners. Also, landowners have stated that previously there has been a person at Trent Lodge, which is situated along Trent Walk, and this person allowed access through a gate for members of the public to access Trent Walk, but people would need to seek permission to get through. However, it's not clear from the evidence, though, that the gate was manned during the period of time the users alleged to have used the route. So it's not clear that there was somebody at Trent Lodge between 1979 and 1999 checking or allowing access for members of the public to use Trent Walk. Issues have also been again raised about the validity of the 1801 order, but as stated in the previous report, the documentation was reviewed by Dr. Fawkes, who raised no issues with the validity of the document, and therefore officer's opinion remains that the order is valid and relevant. Some safety concerns have also been raised in relation to a golf course being built along Trent Walk and the possibility of stray golf balls. Also, it's been advised that people do own shooting rights for Alders Coppice and Populous Coppice, which also again run along Trent Walk. So concerns have been raised about the possibility of members of the public being at risk of accidentally being peppered with gunshot. As has previously been stated, whilst it's not our intention to belittle any concerns raised, particularly issues relating to safety, as stated, as the law stands, these issues cannot be taken into consideration when determining a Section 53 application, only material that relates to the existence and status of a route can be considered. As with the previous application, this application is based on 2 tests, so whether the route can be shown to exist on the balance of probabilities or whether it can be reasonably alleged that the route exists. So on balance, when the user evidence is reviewed in conjunction with the quarter session order, it can be argued that on the balance of probabilities, the route does have bridle rights over it. The order refers to Trent Walk as a bridle way, and there is no evidence that any rights over the way have ever been legally extinguished. Whilst there are contradictions between the user evidence and the evidence provided by landowners, there is evidence that the whole of the alleged route from Trent Walk to Home Farm Court has been used by the public in a way which is consistent with the route having the status of a bridle way. And there's been no clear or overt evidence that clear action was taken by any landowner to rebut any presumption of dedication. So therefore, it's officer's opinion that on the balance of probabilities, the alleged route from points G to H at Appendix B does subsist as a public bridle way, and therefore the application should be accepted. Thank you. Happy to take any questions.
Thank you, Hannah. Could you just clarify for me again? I think you mentioned it a couple of times. How many statements have we had from horse riders that they've ridden that route?
And so in total, we had 23 user evidence forms from members of the public. Only 2 of those user evidence forms did confirm or state that they used the route on horseback.
Yeah, I've got to sort of flag up that I'm slightly concerned that considering there's a stables at Ingestre that only 2 people in the history of this application have actually used it for horseback. So I'm not totally convinced. Mick, do you want to say something?
Thank you, Chair. The application was originally made purely on the historical documentation submitted by Martin Ray. And there was a later application for the same route, which was made by Mr. Bedsall, the cyclist's representative. The question of whether this is a bridleway or not could technically be divided into 3. The first is whether on the historical application evidence it's a bridleway, and that comes back to the quarter sessions order and the implications. The second is whether or not there's evidence to support that of contemporaneous usage in 1999 going backwards, to show that members of the public have used it, or it's a combination of the 2. You're quite right, Chair, that 2 people using it on horseback doesn't necessarily indicate a great use by horses, but we have no other evidence. With regard to the issue of cyclists, you can't use evidence of use by cyclists to support, as Hannah's correctly said, an application for a bridleway. Because the only reason that cyclists can use a bridleway is that they were given the right specifically in the Countryside Act 1968. Prior to that, it would have been a criminal offence. And the rationale was that, you know, these routes could be used by cyclists, therefore we'll give them permission specifically in legislation. Because in legislation, technically, since 1898, no, I'm wrong there, a bicycle is classed as a vehicle, which is why you can't ride one on the pavement, because you can't drive a vehicle on the pavement. So it's the same, it's classed in the same manner. However, I have to say, I'm duty bound to inform the panel that there is another alternative to the fact that, one, you go on the historical evidence, two, you go on the the user evidence, or three, you go on the combination of the two. Cyclist evidence could be said to provide proof that the route is a restricted byway, which is open to non-mechanically propelled vehicles. We haven't gone into that because we think it may be a step too far. But I have to advise members that it is a possibility that the user evidence could suggest there are higher rights. Rights for a restricted byway. But you can't use the cyclist evidence to say this evidence of public use for a bridleway. Does it all make sense, Chair?
Yes, it does. Just one other thing I should have asked is there any representation from the local member? Which is John Francis.
No, we've not had anything directly from them.
He did say to me that he was unhappy with the applications for industry, so we just sort of note that he's unhappy, and he's passing on the thoughts from the parish council. The parish council again, just what did they say?
So the parish council have raised some concerns about the validity of the 1801 order, and they have raised some concerns about the impact it would have on local residents.
Thank you. Have we any other thoughts from members? I'm obviously still concerned about two users, and I think I won't be voting for this because of that reason, because I don't think it's balanced. But just that's my views. Just to finish off there, David.
Chairman, more on a general point than on something specific that does apply to this. If a bridle way has fallen into disuse but is there on historic records, then once a highway, always a highway, regardless of whatever usage is shown of that. I mean, lifestyles change, rambling, cycling, and all the other sort of things have come in more recent years. But if there's no record of the existence of a bridle way, then there is no prospect of that bridle way being used because it isn't indicated anywhere. But presumably, if it once existed and it's now come before us, just on the basis that there is evidence of its existence, we need to approve it. The evidence that we've got of usage is supporting that evidence rather than being critical to the evidence. Is that correct?
Yes, Councillor Smith. As I said, the application, you can be divided and separate the evidence out. You can discard the user evidence as being somewhat debatable, and certainly not sufficient to attest to any strong usage or a lot of usage at any rate. Although you might want to consider at that point whether the usage supports the fact that it's a footpath. However, the historical evidence is the same evidence that you've made the decisions on the other routes, because it's all founded upon the Quarter Sessions order, in which Earl Talbot himself agrees that, you know, this is a public bridleway, the Trent Bridge will be a public bridge and I will maintain it forevermore, and so on and so forth. And one has to bear in mind that this was prior to the 1835 Highways Act, which introduced some new provisions. So his lordship was quite entitled to do all this. Although I have to say that procedures were somewhat looser in those days for members of the aristocracy than they might be for the ordinary man. And that's noticeable in the historical records. But yes, this can be treated as a pure historical application, which is what it was originally. I have to say that it might not have been accepted as an application for a bridle way on the basis of the user evidence that was submitted, because it didn't really qualify for that type of application. But because we'd already got an application, it was simply added to it. But yes, you are right, the historical record would take precedence, and if something had fallen into disuse and then at a later point was picked up by the public again and started to be used, the fact that the public had started using it again is evidence that, you know, it's a necessary route, if you like. But the historical record, if that can be proven or shown to prove that the highway existed at a certain point in time, then it still does. And I have to say, the oldest historical application that this panel has ever dealt with was from the end of the Civil War in 1649, when the panel approved an application based on a court order which said that the parishes were liable to repair the bridge and road which had been destroyed, whether by the Roundheads or the Cavaliers, I can't remember. But certainly we had to consider putting a new bridge in. That was the evidence that we did. We actually did a diversion order, I have to say. But the evidence showed that in 1649 there was a highway there, and so there still is. And I would remind members from the training that if you can prove that at any point in legal memory, which goes from the 3rd of September 1189, you can prove the highway existed, it still does, unless it's been legally stopped up.
Can I just bring the chairman in, please?
Thank
Paul.
you, Chair. Thank you. I was basically going to say a lot of what David has said, but on this committee over the last 5 years, we've been consistent. I think what Mr. Worth is saying there is that we need to continue to be consistent, really. The last one, we looked at the historic evidence going back to the 1801 Quarter Sessions Act, and the fact that there was a bridle way in existence from then. Earl Talbot said there was, gave reasons to do it. I know we can't accept the cyclist evidence as use of bridle way, but we can accept that it was use, that whatever it was being used, and that people weren't being prevented from using it. And the landowners actually say they prevented people from using it. But if cyclists are using it, as horses have used it, it's just showing it was being used. And that's all use that. So it's not as if it's fallen into total disarray. But as David has said, once a bridle way, or once a highway, always a highway. So for that reason, I will be supporting officer's recommendation.
David?
I was only going to add to the officer's report and also the advice that we've been given by officers. I don't see how we have any choice but to approve the officer's report. And I'm happy, if Paul has proposed, that I will second that.
Jill?
Thank you, Chair. Yeah, I would agree with what's been said. You know, once a highway, always a highway. And I would agree with David that lifestyle changes can affect how it's used and when it's used. But I feel that there's enough evidence being submitted, and I will support it. Thank you.
Do you want to speak for?
Just on the question, yeah, you know, said that you have to follow officers' recommendations. You know, actually, it is open to the panel to disagree with us, and it has happened in the past on a few occasions, to my great dismay. But it is your choice. You are the tribunal of fact and tribunal of law. We can make recommendations, but it is up to you to make the actual decision. So if you determine that the facts you are interpreting them don't fit our recommendation, you're entitled to say so, entitled to take that decision. So you don't actually have to follow us. Yes, it may seem that it's against the law or whatever, but again, you are the tribunal that can do that. So it is entirely up to yourselves. We're here to advise you and to assist you, but we're not here to make the actual decision. That's for yourselves. So I would say that, a little caution, it's not that you don't have any choice, but if you're following the facts and the law, in a sense, you don't have any choice. You're making the decision based upon those.
Okay, just David.
I was only going to say, on that advice, this panel would be very, very foolish to start rewriting the law. The law is the law, and we have to legally interpret it and make decisions on the basis of the law. We can't start rewriting it, and so I stand by my seconding approval of the officer's report.
Can I also add that, thank you Mr Murphy for that. As you know, I have voted against officer's recommendation previously at this panel, but I've made my decision on the training we've received, as well as listen to the officer's recommendation, listen to the way Hannah has excellently put it across, and it's really my own interpretation of the law and what's been said in the document.
Thank you. Thank you, everyone, for the input there, and thank you, Mick, for the advice. Going on that advice, I still disagree that the user evidence for horses is strong enough. However, I do feel this hand from the history of Lord Talbot on my shoulder, saying that he signed it off at the time. It was his land to sign off and divert footpaths and whatever else went on at that point. So I would agree entirely with everyone and what's been said. It is a legal document. We must follow that advice. So I would agree with the rest of the panel, and we'll go with the officer's recommendation there. Okay, thank you. Mick?
Can I just clarify a point, just for officers, for when we come to make the order on that? I'm going to suggest that the basis of your decision is upon the historical documentation. Would that be correct, Chair?
It's correct from me, but I don't know about the rest of the panel.
Yes.
Chairman, I think the historical documentation is, beyond all else, a basis for our approval. Everything else we've got is just supporting that recommendation.
Could I also ask that we write to the shooting club and the golf club to let them know that we're going ahead with this, that we've made the order, and it's then because it's then down to them to ensure the safety of people on the footpath, not the other way around.
There is legislation in place regarding shooting. You can't discharge a firearm when, so you will know this is an
50 yards.
Yeah. Which, with a shotgun, means that you can't actually get round to properly shooting somebody. But there is legislation saying you've got to fire away. If you've got a shoot going on, you've got to marshal it and all sorts of things. With regard to the golf club, they have a duty of care not to make sure that, you know, nobody gets injured, and that's the same if the golf club runs alongside the highway. I have to say, though, there was an example in Pembrokeshire, as people will be aware, there is an awful lot of army training goes on down there, and there is one place where a public footpath runs on the edge of a golf course and at the side of a shooting range. So your danger is, it actually says on the footpath, beware golf balls, beware for live ammunition. So, you know, in that situation, you've actually got both. So it's not an unusual circumstance, but we will highlight it, and obviously they will be given a copy of the order if they are relevant landowners.
Thank you. Right, well, we'll move on to item number 6, which again, Wildlife and Countryside Act 1981. And this is an application to upgrade public footpath 21 Hixson to a public bridle way. Again, Similar vein, I should think. Thank you. Hannah.
Yes, thank you, Chair. So yeah, as stated, this is an application to upgrade Public Footpath 21 in the Parish of Hixson to a public bridle way. So this application considers evidence that has been submitted in the two previous applications submitted by Mr Martin Ray. The evidence to consider with this application is a Colwich Enclosure Award dated 1791 and again the Quarter Session Order dated 1801. The plan with the Colwich Award shows Trent Walk, which is referred to in the award as one public bridle road leading from the westwardly end of the said public carriage road therein before set out called the Shirleywich Road across the said Turnpike Road into and over in a westerly direction the sixth allotment to a bridge over the canal and across the said bridge into and over the fifth allotment to and from an ancient ford in the River Trent called Industry Ford. As previously stated, the Quarter Session Order refers to the diverted bridle way subject to the order running from Trent Walk, and it does refer to a public bridle bridge erected over the River Trent. So just to clarify, the route subject to this report continues from Trent Walk in a north-easterly direction, passing the River Trent and connecting to the A51 along Trent Lane. So looking at Appendix B, this route runs from where the previous route ended at point G, and this route runs along the line from points I to J. So enclosure acts were designed to enclose the old commons, manorial waste and smaller holdings in order to increase agricultural productivity. Enclosure commissioners could create or divert public or private routes if the Act set out that they have the powers to do so. The award clearly refers to Trent Walk as a public bridle road, and it refers to its continuation to the canal, which would now be the Trent and Mersey Canal, and also to the River Trent. So the route subject to this report starts at the point where Trent Walk meets the River Trent and then continues across the Trent and Mersey Canal, connecting with the A51. So the fact that the award clearly sets out that Trent Walk has the status of a public bridle way strongly supports that the route has bridle way status. The enclosure award predates the 1801 order by some 10 years, as well as the construction of the bridge over the River Trent. So at that time in 1791, the river appears to have been crossed by a ford. The enclosure award does coincide with the Quarter Session Order dated 1801. The consent with the order, with the Quarter Session Order, states that the bridge over the River Trent is to be maintained by the Earl of Talbot and used as a public bridle bridge as part of the diversion. So clearly implying that the full length of Trent Walk and the bridge at that time were to be public bridle ways. This evidence is supportive of there being a network of public bridle ways in the area, including Trent Walk and the bridge over the Trent and into the Turnpike Road. Following circulation of the report, correspondence was received from Hixson Parish Council, who have stated they support the application to upgrade Footpath 21 to a bridle way. We have also received some comments which were received quite late on from two landowners who have raised some concerns about the proposal. They've stated that the footpath is not well used. They've stated that the footpath runs adjacent to fields that are used for agriculture and animal grazing. So they've raised concerns that if the footpath were to be upgraded to a bridle way, it would mean additional fencing, animal management planning, preparation for safety regarding gate locks would be needed, and the potential of possible animal-to-animal contamination. So again, as previously advised at this meeting, whilst these concerns are noted, they cannot be considered when determining a Section 53 application. A request was also made regarding whether the route could be diverted. The purpose of the Section 53 process is not to create new public rights of way, but to recognise existing public rights of way. and to assess the evidence as it is before us. So the test in this case is to show whether on the balance of probabilities that it is more likely than not that the existing classification of the route is wrong. So if the evidence is evenly balanced, then the existing classification of the route as a footpath should remain. So in light of the evidence provided by the quarter session order and also the enclosure award, it does appear to be clear that Trent Walk and the line of the alleged route does have the status of a public bridle way, and therefore the evidence is supportive of the alleged route having bridle rights over it. Therefore, it is officer's opinion on the balance of probabilities that public bridle rights do subsist along Footpath 21 in the parish of Hixson and therefore should be upgraded. Thank you. Happy to take any questions.
Thank you, Hannah. Any questions, thoughts from officers, from members?
I think this
Paul?
is the clearest evidence of them all, really. Going back to the two dates, 1781, 1801, and then what Earl Talbot has said, the maintaining of the bridge as a bridle bridge. So I'm in favour of supporting officer recommendation.
David seconded. Again, we've got that hand of Earl Talbot on our shoulders. So I think we will obviously as a panel agree with the officers on this recommendation and take it forwards. Hannah, thank you so much. It's been a lot of work for you this morning, and not always simple either, mainly because of members asking questions or even me. So thank you very much, and thank you, Mick. We'll move on now, please, to exclusion of the public. And I'd have to say these words, that the public be excluded from the meeting for the following items of business, which involve the likely disclosure of exempt information as defined in the paragraph of Part 1 of Schedule 12A, as amended, of the Local Government Act 1972, indicated below. Thank you. And we'll just wait for to be disconnected.